Hey, can you hear me okay, or is our testing 1, 2? Is that Jen, can you hear me okay? Okay, good morning, everyone. Members of the Indian Child Welfare Act Task Force, and to those who are joining us live on YouTube and those who are participating with us here today. My name's Lloyd Larson. I serve in the House of Representatives and am one of the co-chairmen for this task force. The other co-chairman, Senator Raffy Ellis, has had some family issues come up and was not able to make the trip here from Cheyenne, may be joining us on Zoom. But I think that may be a bit intermittent as she's en route to be here tomorrow for tribal relations, that she is also the chairman of. This task force is put together by members of the House, the Senate, and then appointments by the governor. We have the Director of Department of Family Services, Director Corin Schmidt, who is a member. We have a county prosecuting attorney, Kevin Tahiri, that is here with us. Donna Payton, a private attorney who practices out of Laramie. We have two persons that were recommended by the Eastern Shoshone Business Council and approved by the governor, Councilman Waylon Large and Vernalyn Bering, who I believe is the director for Eastern Shoshone Department of Family Services. Two persons recommended by the Northern Arapaho Business Council and appointed by the governor, Northern Arapaho Attorney Claire Johnson and Councilman Karen Returns to War. From the Senate, we have Senator Affy Eldis and Senator Kel Case. And from the House of Representatives, we have myself and Representative Forrest Chadwick from Casper. So with that in mind, and prior to further conversation, we'll go ahead and do roll call.
Senator Kel Case.
Present.
Representative Forrest Chadwick.
Here.
Ms. Claire Johnson. Ms. Donna Playton. Ms. Karen Returns to War. Mr. Kevin Tahiri. Mr. Waylon Kyle Large.
Here.
Ms. Vernalyn Bering. Co-chairman Ellis.
Excused.
And co-chairman Larson.
Here. Just for information, we'd like to extend our congratulations to Mr. Tahiri, who was just appointed as district judge in Casper. He was the county attorney in the Casper area. And Mr. Tahiri, I think is that going to have an impact on how you serve in this committee? And please accept our congratulations. That's a big honor and it's a big dang deal for you. It looks almost the same. Yeah. Thank you. Just a little housekeeping for the members of the task force. As we have conversations today, we'll go by the legislative rules, which mean all of the questions come through me. So if Ms. Johnson is going to ask a question or make a comment, she'll ask for my permission to make that, and then that conversation between those needs to come through the chairman. It just maintains some order and prevents some back and forth that sometimes can get a little bit a little bit out of control. And I would also mention to the members of the task force, as we get into this conversation a little bit further on what we're going to do and how we move forward, there will be a lot of ideas and suggestions that will be welcome in what we need to hear. But I would ask you, please, if we have members of the public who come to make public comment, and if you have wish to engage with them, it needs to be in the form of a question. We want to ask them questions, not opine on our opinion based on what they've said. We're here to gather information to help us as a task force make more informed decisions and a plan forward. So if you have a question for a public comment, please make sure that's in the form of a question. And again, that will go through me. So members of the task force, just for the benefit of the public, I would share that this task force, upon being organized, reached out for some expertise in helping us navigate through this conversation. We have previously, through the Select Committee on Tribal Relations, had help from the Annie Casey Foundation and also from Professor Kate Fort, Michigan State University law professor and expert on Indian child welfare law, that presented to us. We extended a request to them that they might help us better understand the issues around the Indian Child Welfare Act and the challenges that we have. They both agreed and have been very helpful. They met with this committee in an informal meeting to help us understand what the Indian Child Welfare Act is, the history of it, and what the rationale behind having this task force. And for the benefit of the public, the rationale or the necessity of having this task force is, as the Indian Child Welfare Act was adopted in 1978 to protect and preserve cultural heritage and preservation of sovereignty in tribal families and tribal nations, that was granted to them through treaty. We have found in various states that this federal law has been challenged from time to time. A couple of years ago, there was a case that originated, I believe, in Texas that challenged provisions of the Indian Child Welfare Act. It was appealed up to the Supreme Court. The Supreme Court agreed to hear the case, which was titled Brackeen versus Holland, Holland being the Department of Interior, who has oversight over tribal issues. In response to thoughts and opinions on what the Supreme Court might do, there were really two, actually maybe three options that were presented to the Select Committee on Tribal Relations, and that is that the Supreme Court would do nothing to the Indian Child Welfare Act. It may address provisions of the Indian Child Welfare Act, or it may overturn the Indian Child Welfare Act. The state of Wyoming has had up to that point not had a Indian Child Welfare Act put into their state statutes and complied solely with the federal law. And so the question that we had was, if ICWA is overturned, what then, or how do we administer protective services and parental and adoptive services for Indian families that come under jurisdiction of courts in Wyoming? In response to that, we felt that creating this task force to make recommendations back to the legislature in the event that the Indian Child Welfare Act was overturned or provisions of the act were changed, what we needed to do to accommodate those. The second thing that happened during this last legislative session is the legislature codified the federal Indian Child Welfare Act into our state statutes with a sunset date that would have allowed us, if ICWA was overturned, to continue on using the federal law now as our state law to govern how we administer the actions under the law. So with that history, we'll just make note that the Supreme Court did hear it. They upheld the Indian Child Welfare Act, which then puts again as the baseline across our nation for child services dealing with tribal families, as the federal ICWA law is the baseline. I think our challenge will be, do we then just go back as we have and just comply with the federal law, or do we keep that as the baseline and enhance and make more restrictive? And so as we hear the conversations today, when we conclude, I think that we will make some motions on whether we just make a recommendation that we just stay status quo and comply with the federal law, or if we have some suggestions that might enhance this federal law in our state law to add clarity and ease in the system to deal with parental rights and placement of Indian children. So with that, we've asked David if we could talk a little bit about the Indian Child Welfare Act. Was that going to be, is there anything here that we need to discuss further, or any other part of this provision that we need to go through in our state statute?
Mr. Chairman, unless you've got something specific that you wanted to address, we didn't have anything specifically prepared on that particular topic.
So we're going to be a little bit, we had hoped to have Professor Fort talk to us about the Brackeen case. She's not available till after lunch. So I think we would like to then move in and just have a discussion within this task force on any suggestions that they feel we need to do as they've reviewed the policies of other states, and then that would enhance our Indian Child Welfare Act. So I would entertain any comments from the members of the task force. Ms. Johnson?
Just
Don't
where
be,
you say thanks a lot.
yeah.
Chairman Larson, so there are about 16 other states in the United States that currently have state ICWA legislation. I have worked.
Claire, could you get just a little closer, please?
Yeah. Having practiced in several of them, there are provisions, particularly in the state of Washington and the state of Oregon. Under the WICWA law in Washington, they allow a tribe, and I've done this myself as a Northern Arapahoe's attorney, to present our standards for placement of Indian children under tribal law, so that a judge in a court case can use that in addition to the federal placements, because sometimes tribes have a different priority for placement. So one recommendation would be to allow the tribe to use, or a judge to at least review the tribe's placement preferences. Another thing in the state of Washington,
Ms. Johnson,
sorry.
sorry, Ms. Johnson. So could you give us an example of that? I don't know that I'm tracking quite how that works.
Okay, so example, in a case you have the normal, the federal law approved placement set forth under ICWA. Now, in the case I'm doing currently in the state of Washington, I was allowed, Northern Arapaho has passed a resolution further defining the placement preferences and adding geography into part of how they place them back within the boundaries of the reservation. So in that case, when we were looking at a placement preference for the two children, I was able to present the tribe's resolution on placement, and the judge could consider that as part of his determination when looking at an appropriate placement under the federal ICWA law.
And then does that require then the state where the action is being considered to accept? I'm trying to figure out what it is that we need to have. Do we need then to be able to accept the foreign entities counsel as then being licensed to present, or I'm missing what the structure is there?
Well, with this one in particular, it's not about the council itself. It's about the tribe's law. And so I was able to enter the tribe's resolution on ICWA placements as evidence in that placement proceeding. And it's something that then the judge is allowed under WICWA to take into consideration.
Okay. Continue.
Also in the state of Washington and several other states, there is a provision that allows tribe's attorney to come in, even if they are not barred in the state, to represent the tribe. So like in the state of Washington, I enter a letter to the Supreme Court of Washington. They approved me to come in, even though I'm not barred in Washington, to practice solely for the purpose of the ICWA case. And this is incredibly nice because it saves the tribe a lot of money. Instead of me having to find local counsel, pay pro hoc fees, I can be admitted solely to represent the tribe for the purpose of an ICWA case. And I've done that also in the state of Nebraska, allows the same thing, which it just helps because, you know, tribes often have limited resources, and, you know, having to hire outside counsel to go and intervene in a case can be quite costly. And this just allows more flexibility for the tribe's attorney to come in.
Okay. Any other thoughts?
That's all I have at the moment.
Okay. Director Schmidt, anything from DFS?
Thank you, Mr. Chairman. We would like some conversation or consideration about how Wyoming ICWA applies to juvenile delinquencies.
I can't tell from that.
Can you hear me okay?
Is it working?
Yeah, I think the
Francis
green light.
says yes. Good.
I'm
sorry.
good. No, you're fine.
Yeah, but get closer. I'm with Gail.
Better? All right. Thank you, Mr. Chairman. We would like some consideration given to the application of Wyoming ICWA to juvenile delinquency cases under Title 14. In the federal law, the delinquency cases aren't contemplated as ICWA, but in the codification of the federal law into state statute, there was a generalization made across all of the three actions that occur in Title 14. So child welfare, children in need of supervision, or child protection, children in need of supervision, and juvenile delinquents. We think it was just a matter of how quickly this all came about, but we would like to have a conversation about removing delinquents as part of the ICWA codification of state law.
If I may refer to the engrossed version of the bill that I believe we have coming. That's in 14.6.201. And we added a new D that talked about if a child or minor alleged to have committed a delinquent act, maybe amending that state law, deleting that section, but would the rest of the changes we made in 14.6 stay?
Mr. Chairman, yes, it would be the deletion of D. And then also a change to the session law in this section 3 to eliminate to delinquency petition. And I don't know how that is done within this process, but it's part of the bill. It's not part of the Green Book, but it does have reference to delinquency petition in section 3 of the original.
So if we might go to LSO and ask them on section, I don't think we have to amend section 3. We just have to amend and delete that provision if that was the task force's recommendation. Is that accurate, David?
Mr. Chairman, in drafting a bill along those lines, perhaps just for clarity, I might do it. Just to be clear
Okay.
that that's what we're doing, but
So with that thought from Director Schmidt, are there any concerns from any of the Senator Case?
Mr. Chairman, thank you. Can I have the low-level version of why delinquency is not part of ICWA at the federal level? And I mean, I guess I understand that delinquency involves the courts and punishment and we don't want that necessarily to tribal governments to have influence in that, or that it was never envisioned by the federal law. It's not appropriate. I'm just trying to see how it works in practice and just trying to get my arms around it. I know nothing.
Thank you. Thank you, Senator Case, and I'll ask Director Schmidt to opine on this or Mr. Tahiri, but as I understand it, ICWA is really trying to protect the structure of family and the parental rights that are granted to a family. And in a delinquency case, those aren't impacted. It's just that this child has committed a crime and is being in none of the other aspects of the structure of family or are being challenged. Now, if that child in the process of the delinquency hearing finds that there are issues that warrant, this is all hypothetical, that warrant that parental rights be terminated, that's a separate action. And that would be covered in ICWA. Mr. Tahiri, do I have that right?
Yeah, so, Mr. Chairman, my understanding of ICWA, it only applies to child custody proceedings under federal law. And they exclude delinquency from the definition of child custody proceedings. And they exclude divorce proceedings from the definition of child custody proceedings. I don't know the underlying policies behind that. I mean, we could always consider that as a group if we want to keep delinquency in, or if it should be removed consistent with federal law for the reasons that you stated, Mr. Chairman. I could see some pros and cons to both ideas, and I get DFS wanting some clarity on that, because the way I read the state law, it also didn't define delinquency as part of child custody proceedings, but then you had that language later that kind of muddied it up a little bit. So I just think we need clarification on that one way or another, if that's the direction we want to go or not.
Ask a dumb question.
Well, they're not. We need to make sure that we're clear. And as you see me scooting around here, I just want to make sure, because those of us in the legislature are comfortable with kind of having this back and forth, and task force members, if there's questions or concerns or wondering why Senator Case pointed out now's the time to ask a question. And so if there's concerns on this conversation, because this task force will probably be making a motion to draft a bill that then we can refer to probably judiciary to amend the state statute accordingly. So if you're not comfortable with this type of proposed amendment, let's have that discussion. Okay. Ms. Bering?
Mike was not on, sorry, Chairman. I do have a thought process along the lines of that question. If the Wyoming ICWA was to be
Lynn,
enhanced,
you're gonna have to stay pretty friendly
If-
with that
if-
mic. There you go.
okay. If the ICWA, the Wyoming ICWA was to be enhanced through, and put into place, and along the lines of that question. My thought process is if a juvenile delinquent required child protection services and did not have a guardian, then that delinquent would fall in line with child protection services and could possibly fall within that, fall within ICWA. So if ICWA was to be enhanced, as stated for the Wyoming, state of Wyoming, that could be a consideration to keep open rather than to delete that completely out, because there are delinquent cases that require child protection services.
Thank you. And so I think that begs the question, and we may have to Mr. Tahiri or Ms. Clayton, or maybe even Mrs. Neely, as if you got our attention. Now I'm good. As we had this conversation, am I correct in making the assumption that you could have delinquency proceedings taking forward at the same time that you're having protective services, but they're governed differently? Yeah. And so by removing the delinquency requirement of ICWA out of statute does not dilute the protection or the implementation or adherence to ICWA for that child in those protective service hearings. Have I got that right? Does that help?
Mr.
Councilor
Chair,
Large.
Mr. Chair, if that required, just with Mrs. Returns to War Council lady, it would be, oh, help me clarify this, Karen, I would be just with, regarding taking out the delinquency, because still they'll be under the jurisdiction of the tribe, or would it be Eastern Shoshone or Northern Arapaho? If you want to comment more, Karen?
Can you share with Karen a little bit? You're being a microphone hog.
Chairman,
Councilman Returns to
so
War.
my concern there is we're talking about placement of our children. And when our children get involved with delinquency and DFS gets involved, then placement is a part, probably possibly part of that delinquency petition. So that's kind of the way I see it. So I do believe that the delinquency part needs to remain because it's most likely going to address the placement of our children. Thank you.
Mr. Chairman? Can you hear me?
Oh, I heard a faint voice
Senator
as
Ellis?
he was driving down the highway somewhere. So yes, if we can let Chairman Ellis in. Go
Thank you,
ahead.
Mr. Chairman. Thank you, Mr. Chairman. I think on this discussion, I'm even getting a little muddied on how this works. So maybe Department of Family Services could just walk through the process. As you know, Mr. Co-Chairman, we have done so much work on our absenteeism statutes to try and make sure we're doing everything right when you have an Indian student involved. And some of that requires an analysis of where the student lives. You know, are they living on reservation or off? But maybe the department could just walk us through the delinquency issue. You know, it arises with, you know, a student who maybe is absent from school. That's one example, but there might be others. So I think that would be helpful because I'm also getting a little muddied on whether or not just a straight delinquency action where you have parents who are trying their best, there's no child neglect. You know, are they ever considered for outside family placement?
So I think, and this is why we're so glad that you're here, is because we have to talk about the jurisdictions and where ICWA is really enforced. And so we've got Miss Bering, who is the director for Eastern Shoshone Department of Family Services, Director Schmidt, and we have our field office director, Miss Jen Neely, who really coordinates in Fremont County between state and tribal issues. And so I think the conversation that we're having on delinquency, and would ask you, Jen, if you could help walk us through perhaps some scenarios, but we have to bear in mind that if the delinquency, the juvenile delinquency, takes place or is brought to a juvenile who's living on the reservation, that automatically goes to tribal court. Or is it where it happens? Anyway, can you walk us through the scenarios? I see you giving me the stop before you ruin it look here.
Thank you, Chairman. I really need to work on my poker face, apparently. And I don't know that you were too far afield. One of the things just to remind folks as we have this conversation is that ICWA cases are very unique in Fremont County and Hot Springs counties because of the contract that we have in place with the Northern Arapaho and Eastern Shoshone Business Councils. So I'll give different answers to those scenarios. So if a child comes into custody under a child welfare action in Fremont County, that action is then automatically transferred to the Wind River Tribal Court. And the corresponding tribal DFS offices who manages those cases and then makes decisions around placement. In any other county in the state, if a child comes into custody and meets the ICWA criteria, then that court and that DFS office go through the process of notification and working with the tribe to determine what's going to be in the child's best interest. For juvenile delinquency actions in Fremont County and Hot Springs County, it's a little bit different. Those cases don't get transferred to the Wind River Tribal Court for prosecution, but the Northern Arapaho or Eastern Shoshone DFS offices have standing with the district court. So they appear in the district court on behalf of the state/county district who's filing those charges. Mr. Chairman, I want to make sure I get all my legal terms correct there, but.
Mr. Chairman, so I think I'm not real familiar with how it works in Fremont County or Hot Springs on the reservation. I know in the past that if a delinquency is filed, it wasn't considered, even if it's an Indian child that say commits a delinquent act in Natrona County, then there would be no tribal involvement because that wasn't considered an ICWA case. There are placements that can be made. And so I can see the concern that perhaps there's a concern that Indian children are, for example, maybe being placed in the boys' school or, something like that, that would be a placement. And I could see why the tribe may want some say in that. At the same time, the ultimate goal in a delinquency is almost always reunification with the parent. Because if the parent hasn't done anything wrong and there's no neglect, your ultimate goal at the end will be reunification with the parent. So the termination of parental rights concerns aren't really there, that they would be in a neglect case. I hope that answers some of that question.
Is that not the basis behind ICWA?
That's one of the main reasons behind ICWA, is because in the history, it involved taking children away from Indian families to essentially change their culture. And if you read the Brackeen case and the Gorsuch concurrence, it will give you a lot of that history. And so some of the concerns won't be there, but I can see that some of those placements can last for years. So maybe the tribe would want some say. And I guess my main point on that subject is the statutes have to go one direction or the other, because if you read it right now, this only applies to child custody proceedings under 14.6.703. And then if you look at your definition of child custody proceedings, it does not include a delinquency. A criminal act committed by a child is how it's phrased, but that would basically be delinquency proceedings. And then later it talks about applying it to delinquency proceedings. So I can see where DFS is somewhat confused. So.
Ms. Perry, did you have any thought?
Yes, Chairman. I don't, my understanding of you know, the enhancement of providing ICWA services for Wyoming and the residents and the tribes of Wyoming. So I'm gonna do a little bit more reading and some research with and getting you know, caught up with the goals and some outcomes that the state and the tribes are reaching for. But I want to go back to my thought process. ICWA does, you know, apply to tribal members that live off of the reservation, that live in different states, and not living in Wyoming. So the ICWA, federal ICWA, then focuses on children living off the reservation. But when it comes to Wyoming and forming a ICWA task force and enhancing securities or measures for residents of Wyoming, that is the piece that I'm have interest in wish to continue to partake in. So back to my thought process, if we have a juvenile who is living off the reservation and who has been involved in a court system in some delinquency matters, there is a process that is in place between the state, the courts, and the tribes. We work closely with the state, you know, and working with the different court systems. And so there is a system in place. However, at some point, you know, the contract between the state and the tribe, that also accommodates, or it requires for, you know, the partnership to come into place for matters, cases starting off of the reservation. So for example, if we have a case that opens up and the family is not living on the reservation, then at one time there was a process that was, you know, through the ICWA process for jurisdictions to be transferred to the tribal court. So the contract then eliminated that process. And so the DFS departments now are required to go and respond, which I think that relationship is growing. And so when we have a child and a family living off the reservation and we have a juvenile who may have committed a crime, but however, they don't have that stable or, support of their guardian and are standing without a guardian or standing without someone who can follow and support them through that delinquency matter, then that raises question and raises concern that it, where would this ICWA, where does that fall in line that the state of Wyoming is wanting to establish to support that matter. So this is still, a lot of building. There is a process, like I said, that is in place that could be enhanced, that could be more supportive on both the state and the tribes. So if we have a delinquency matter and a child does require, child protection services, those are the cases that not all delinquency matters require child protection services. So I want to make that all, would say at least may need child protection services, but not all of those matters.
So members of the task force, I think that there's really an interesting structure here in Wyoming that we have to keep our heads wrapped around. And Mrs. Neely, I'm going to kind of refer to you and Director Schmidt a little bit, and then because what Ms. Bering talked about in this MOU, in this contract, and in the interaction of tribal court and tribal DFS for families who, or an individual who may have committed a delinquency act off the reservation, really is applicable to Fremont County and Hot Springs County. And that same interaction between tribal DFS and the state court or the county attorneys does not necessarily exist statewide. And so we have to, Fremont County and Hot Springs County, because of the close interaction between the citizens living on the reservation and citizens off and where the residency is, has naturally created this relationship between the state and the tribes in handling these child welfare cases to be in tribal court where possible. Whereas in the rest of the state, down in Laramie or in Casper, you would take a delinquency case and you would move it through the system and you would look at those options. And the options for placement in delinquency isn't necessarily a foster home. It's where thank you, Senator Case. It's a type of incarceration that is left to the state court. So it's really important that we keep that, whereas in Fremont County, Hot Springs County, that's going to come back. And so the decisions on these tribal members in Fremont County, a lot of times naturally flows, and the placement is really dealt with in tribal court, right? Councilman returns to work, which we think is a strong system to have.
Chairman, you're correct.
Thank you.
So my opinion here is that we have a great working relationship with Fremont County and Hot Springs County. However, we need to expand that to Natrona County. We got numerous tribal members that reside in Natrona, even down in Laramie, with many of our people going to school there. So I really like that this is going to, hopefully this is going to become something that's nationwide, so that everything that Fremont County and Hot Springs County is going to, the rest of the counties throughout the state of Wyoming are going to be able to abide by the same qualifications, and the tribes will have more say regarding our own children. Thank you.
Oh, Mr. Chairman.
Ms.
Um,
Neely.
One thought, I guess, as part of the discussion point that Director Schmidt raised is from a DFS state perspective, just clarifying the guidance if the juvenile delinquency portion is to remain for a DFS caseworker and a court outside of Fremont or Hot Springs counties who aren't associated with the contracts, just some guidance on notification to tribes who may not be prepared to receive notice on juvenile delinquency actions. We would just need some guidance on that, or have some discussion around it.
So I think what you're suggesting in that comment is statewide, the number of tribal affiliations that our judicial system or our attorneys may see is immense. And to have this quirky little piece of ICWA in Wyoming law that refers to delinquency is an anomaly with what we see in ICWA nationwide. And so other states may not be prepared to address or participate in the delinquency portion, which we don't think was as we put our state statute bill together, was not specifically intended to do that. We just, as we crafted the bill, we looked at those statutes where there were proceedings and conformed it to comply with ICWA. This one should not have been there. And we're just trying to rectify that, make a correction back to ICWA as it applies federally across the nation. Is that a fair?
Yes, Mr. Chairman, I think that's fair. And in a quick look at the number of ICWA cases that we've had from August to April of last year or of this year, there were an additional 8 to 10 tribes that we had to reach out to per ICWA. So to your point about how the relationship works outside of Hot Springs County and Fremont County, if there's a child that comes into care in any other part of the state, then ICWA applies, and then we reach out to those tribes. And in that example, that was 8 different tribes. So yes, to further your point, there would be some confusion by the tribe that we contact as to why we are asking or providing notification, and then what are the rules of engagement after that may be confusing.
If we left the provision in there, Mr. Tahiri, soon to be judge, we're going to really pick your brain on this now. Then the tribes would then have a say on what type of incarceration that person, would that also include where? And is that?
It would give the tribes a say in that, whether it was, the boys' school or a group home or probation. They would have a not only a say, but under ICWA, they would have the right to take jurisdiction of the case if they wanted to. And I don't, if that's something we want to consider, then that's what that ramification is, that they can apply for a transfer of jurisdiction to the tribe. So now whether they would, I don't know. I suspect usually they wouldn't, in that circumstance. But they would be able to. And as far as the out-of-state ones go, they might not understand why they're getting the notice. I see that point. Because they wouldn't be used to that, but so I do think that creates some confusion. So I mean, it might be cleanest just to repeal that particular statute if that was not the legislative intent at the time to apply ICWA to delinquency.
Well, and I also, you raise a red flag is the law that they violated is a Wyoming law. And then to suggest that we may possibility defer that to another state to be considered becomes a little wonky.
Yes, I would agree with that, Mr. Chairman, as well, that another state might not understand or be that familiar with Wyoming law.
Another question I should know. What types of infractions are covered under delinquency? And so it's a violation of the criminal code. And I get that, but there certainly are serious crimes that were young people are charged as adults. For example, I would assume that takes any delinquency question off the table. But in terms of what's the universe of crimes that could be committed? I'm trying to get at the severity, the upper end severity of what kind of crimes we're talking about under delinquency. And
So, Mr. Chairman,
Gutierrez.
to answer that, the Delinquency Act, the Juvenile Delinquency Act, on the Juvenile Justice Act, I should say, defines delinquency as any crime committed that would be a crime if committed by an adult. And then it has sanction levels. So if it's a misdemeanor, that's considered a sanction level 1, which is a suggested sentence within that. And then it goes a high misdemeanor, the 2, 3, 4, and 5, all the way up to, certain levels. Certain acts have concurrent jurisdiction where the person can be charged as an adult as well. So under Wyoming law, if you commit a misdemeanor, you can go to circuit court on a misdemeanor and you wouldn't go to juvenile court, or you could go to juvenile court. Then there's a single point of entry system where the prosecutor has to make a decision. Does it go to juvenile court or does it go to the adult court? And then you have certain acts such as violent felonies committed by anyone over the age of 14 can be charged either in juvenile court or they can be charged as an adult. And then if they're charged as an adult, they can move to transfer it to juvenile court. So there's a lot of things in play there. That have committed low-level crimes, but you tend to think they need a lot of services. So that's why you would bring a child like that into juvenile court. It could be something as simple as shoplifting, something like that, misdemeanor shoplifting. But there's such a history that you think they need a lot more services, so you bring them into juvenile court. Or it could go all the way up to, your aggravated robberies, your sexual assaults, things like that as well. So there's a pretty wide range of crimes that they've committed. But the key to when you want to bring someone into juvenile court is usually if they've committed a felony and you don't want to charge them as an adult, you're going to bring them into juvenile court. Or if they need a lot of services. So there's a pretty broad range.
just thinking about that in terms of if I was a prosecutor in a different jurisdiction, you're making decisions about whether to bring charges in a big court, a little court, the juvenile court. If state law had an additional requirement, that might affect your choice of which court to bring it. And so that would sound like a bad consequence, I think, for children and for delinquents in general. If the bias among some prosecutors was to avoid coming under these requirements, the ICWA requirements, ICWA-like requirements. So you tend to bring more things in adult, charge people as an adult. I think that would be a bad outcome. I think we'd all agree that would be a bad thing to put a bias on the scale like that. Am I wet in thinking about that? That maybe we better not go down this road partly because of that reason.
Mr. Chairman, Senator Case, yes. I think that could be a concern. That the bigger concern would be if you had a serious crime. And you wanted to keep it in your jurisdiction, and you wanted to make sure that it was not transferred to tribal court, and you wanted to keep it in your county because you had victims in your county, something like that. That would make some prosecutors might lean more toward charging as an adult just to keep it in their court system. And that would be a bad outcome for the juvenile. Yes. I'm not going to say that a prosecutor should do that. You know, you would hope that that wouldn't happen too often, but I could see that it would, as it could happen with, especially with pressure from the community.
So here's what I think I'd like to do on this matter, folks, is I think I'll have LSO just kind of draft up a bill that would do that to where we've got it in front of us, can read it. And then in our next meeting, that will give us time to consider the merits, pros and cons of such action. And I think it's really important if we still have some confusion on how that would impact decisions by tribal court, and particularly with the actions that our two tribes have now and their ability, that we can pose some questions and get those answered, because we want to be clear on this. And then maybe kind of have, you know, a little bit of summary and challenges that we see from the DFS perspective. And then we can look at that at our next meeting and move that over. Is that acceptable? Councilman returns to work.
Chairman, if I may, could we ask Irina Snosi to come up and have some input regarding this issue? She's a longtime child protection DFS worker with both tribes. Thank you.
That's a grand idea.
And it's good to see that we have a task force. I didn't realize we did, Wyoming on the ICWA. So, but my question is, it's federal ICWA we're talking about today. So we're taking judicial decision from an existing law which excludes juvenile delinquency and divorce proceedings. So is that the purpose of this task force then?
So perhaps I can answer that. No. Okay. So the reason for the task force is, as you recall, is the Supreme Court in the Brackeen versus Holland case was considering challenges to the federal ICWA law. We were concerned that the ICWA law provisions of it may be altered through the Supreme Court action or overturned in its entirety. And so this task force was put together to then respond in the event that the Supreme Court made a ruling that impacted ICWA, to determine then how the state would move forward in absence of what the Supreme Court done. And the question is do we want to, would we still comply with the intent of ICWA in the state, or do we just, ICWA evaporates and goes into the air and we just comply with state law? And this task force was put together to then make those recommendations. As you well know, then the Supreme Court upheld ICWA in the Brackeen case. And so it still is federal law. And so kind of what we're toying with here now today is, do we just, as a state, continue to comply as we have historically done with the federal law? Or are there some enhancements to that that we can put in our state law that we now have that enhances the federal law? So our most recent conversation on the delinquency is when we created our state law that we didn't have prior to this year. And our state law is exactly like the federal law, except for this one provision where we brought in delinquency. And that was not the intent. We're just saying, is there value of keeping that delinquency in, or should it be removed to add clarity and conformity with the federal law? So does that help?
It does. I believe that a DFS on the state level, they are very, very informed on this whole process with ICWA. So I was a director for almost a year there. And prior to that, I've had experience with the Bureau of Indian Affairs. So we had to apply the ICWA case there.
I'm going to have
Also-
you get just a little
Oh,
closer
okay.
to that mic.
And they are very well informed, and the tribes, I mean, it's all about jurisdiction here. So that's a good question there, but I believe our people have been doing a very good job about if children need to return to family members here on the reservation. That process is pretty clear on the intent of the tribe is to protect their cultural identity. And but I believe that our kids are protected by the tribe. So but it's that I just hear the discussions between everybody here about the delinquency, and that's really it's really a different type of situation with child protection. But Fremont County has that good relationship there, and they know what to do. So yeah, but I believe, yeah, that's my opinion. Is delinquency is a totally, it just opens a lot of legal. It's a legal procedure.
Any other public comment on this, on the delinquency component? And then if not, sir, please come on up, and thank you for being here.
Thank you.
Our formal many years of Department of Family Services Director, Mr. McAdams, thank you for joining us.
Thank you. Thank you for your comments, Irenas. I appreciate them. We may have different opinions on items such as this. I think the delinquency in itself, which I worked, like you said, I was the director of our Eastern Shoshone DFS for several years, many years. And we let the state and whatever the state of Wyoming and what other jurisdictions that the children fall under, we'll let those states courts take care of that issue. But however, in dealing with various states and Wyoming on our ICWA cases, it seems to me that their states are not in it looking at the children. They just want to get them taken through the court process and dealt with there. Our tribe, the Shoshone tribe, has always looked for the betterment of these children. And the Delinquency Act, which we dealt with during my period of time there, I felt wasn't in the best interest of our children. If they're going to go into court and then the court says, okay, you're going to be having to be put into jail, removed from your family, possibly terminating parental rights. I do not believe that terminating parental rights by a off tribal reservation court system is appropriate. I'm very much against that. These children are members of the Shoshone tribe. They are our children. It's always been my intent and my best interest of the children working. When I was working for the tribe, these children have no voice. My department was the voice for these children. And when we did work cooperatively with the state of Wyoming and any other tribe, that I appreciate that very much because it was for the benefit of these children. Oftentimes the Indian people are looked at as second class, if that, citizens, and dealt harshly with. In returning its children to the Shoshone Tribal Court and the Shoshone and Arapaho Tribal Court, we upheld the law. And we've seen that if there was something serious like that, then we dealt with that. And the courts did it also. But we always look forward to working with these children and the families and for reunifying them. I think that the clause that we're talking about, Indian child welfare delinquency, should be left up to the tribal court to deal with. And if it would be best, I think it'd be best interest for the state and other states to transfer jurisdiction to the tribes on issues that are of concern to us, certainly our children. If there was some way that we could work with the state in seeing that could be the greatest option for the termination of the welfare of these children, I would certainly appreciate that. And I would also like to mention that working with the Shoshone tribe, which I'm a member of, we need to have tribal input, not only our business council or the DFS department, ICWA department there. What we really need to have is our tribal communities input here and supporting, or maybe not even supporting it. This, as you may recall, the House Bill 83, which our business council was dealing with the state on, that was never brought to the Shoshone people. When the Shoshone people found out about it, we were against that. And eventually that got stopped. I don't want to see something like that happen with the ICWA program here. So I hope I made myself clear. And any questions?
Any questions for Mr. McAdams? I just have one I want to clarify. So Mr. McAdams, so if you've got a delinquency act, whether it be in tribal court or district court, and in that whole hypothetical situation, there then is consideration for termination of parental rights. That consideration of termination of parental rights has to comply with ICWA. Do I understand that correctly?
I would think so.
Yeah, I think so. And I keep drawing that line because I think we want to make sure that we understand in the federal law that you could have two things going on at the same time. You could have a juvenile who is involved in a delinquent act that in that whole process then may have a consideration of termination of parental rights, even though they're traveling in the same vehicle. They're two different things, and that termination of parental rights has to comply with ICWA. I think am I understanding that the same way you are?
I think we both agree on that.
Okay, any other public comment? I think we are going to take, it's about 10 o'clock. I think we're going to take about a 15-minute break. We might, we're moving here along a little faster than we had anticipated. So Representative Chadwick asked if we needed a motion. I think we'll do the motion on the bill next time. I just want them to craft it so we can see the language and then consideration of that. I just want to get it clarified on how it looks. But I would certainly entertain that motion if you feel more comfortable with it. Are we flying afoul here, Senator Case?
Oh, I think in the end, we're going to come down and say that we got to take delinquency out for a lot of practical reasons and things. But I'm not prepared to just say that right now. I think that's a good suggestion to have it drafted and we think about it some more.
Mr. Chairman.
Senator Ellis?
Thank you, Mr. Chairman. I think, having drafted language in the various components, I think, Ms. Johnson had some good suggestions this morning. It might be helpful to see all these components separately and then, depending on what we want to do, decide whether we want to make individual recommendations on, here are 3 separate things, take them up individually or roll them all into one bill. I would like some time to think about what the best way forward is and what's perhaps most strategic. So we hope we don't move forward with too many motions at this point.
So what we're talking about right now is specifically that delinquent component that DFS brought forward. I think we've already concluded earlier in the meeting that we're going to come back with the recommendations and some to consider that Ms. Johnson brought so that then we can chew on those subjects at our next meeting and decide if we want to move forward with drafts on those.
Mr. Chairman, maybe it would be helpful to see what the draft language would look like from Claire's ideas from this morning, just to kind of advance the discussion of what that would look like, what that language would look like.
That's correct. Okay, let's take a 15-minute break and we'll come back. Okay. I think we're ready to proceed again. I taken a little privilege as chairman and looking at our schedule. And I'm going to adjust it. There's a couple of things we're going to change. We had hoped to have Director or Professor Fort from Michigan State talk to us about the Brackeen case on the majority opinion. And then LSO is going to talk about the dissenting opinion. We're just moving at a little faster speed than we had anticipated. And so we're going to have LSO present that Brackeen position on both sides. And then there's a chance that we're going to conclude earlier than we had hoped. This is unfortunate because I just don't, but Professor Fort just wasn't able to meet with us this morning. So in preparation for that, I just want to clarify to the task force that we'll set up another meeting, and moving forward, we're going to look at some language to consider sponsoring. Now, this committee, this task force can't sponsor legislation. It will be making a recommendation back to another committee on language that they would consider. So as they produce this draft document for it, might be under Representative Chadwick's name or my name or somebody's name, and then if the committee accepts it and moves it forward, then it would change. But we're just looking for language that we can consider to make recommendations. We're going to be in between now and the next meeting, getting a better understanding of allowing the points that Ms. Johnson brought up that Washington State does, and allowing tribe attorneys to represent in other states, and then allowing the tribes to requiring the courts to allow to consider the tribe's placement considerations. I think that there's a couple of other items that come up during break from our Department of Family Services that we might want to consider. I'll ask Director Schmidt, maybe Mrs. Neely, would you mind coming back up? I think you're kind of our local expert here. Can you, I think there's two more things that we want to consider, and I think that we'll need to have some correlation between some task force members, both on this side and this side, to make sure that in our next meeting, we have a concise understanding of what we're trying to do. So Director Schmidt.
Thank you, Mr. Chairman. One of the conversations we would like to have is around the clarification of a qualified expert witness, or a Q, as it's called under the statute, both federal and state. Right now, the ICWA Q definition is a little bit tighter than what the state definition is. And so maybe some conversation about making that a little bit more consistent between state and federal. And I think it has to do with the regulatory part of ICWA as well, not just the statute, but the regulations. And then another conversation, and I'll defer to Ms. Neely on this, is around the interaction between the safe haven law for the state of Wyoming and ICWA. So what the state haven law allows a parent to give over their child to a law enforcement, or to, I think, a fire department and a hospital. Okay. And to give over their child and basically relinquish parental rights, essentially. And when that happens, then there's about a 2-week waiting period. And then if the parent can come back and basically reclaim the child, but if not, then that child will be put up for adoption. So Ms. Neely, if you want to speak a little bit more to some of the examples that you have in how ICWA then applies to that situation.
in our conversation, it appears that the safe haven law come a couple of decades after ICWA was put into place and maybe didn't contemplate ICWA. And so maybe there's some challenges there, and if we can help close that gap, it would maybe be a good thing. So if you could help us understand that a little bit.
Mr. Chairman, I'm happy to give my perspective from an application process, although I'm fully aware that we have a lot of qualified attorneys who could probably speak to the legalities of the issues around safe haven and ICWA. From a practice perspective, when a child is surrendered by their parent without question asked or without criminal charges filed, so that there's no violation on the parent's part if they surrender custody of their child and no questions asked. So that child immediately is placed into state's custody, and then after a certain amount of waiting period for the parent to come back and change their mind or reconsider, at that point, then we just move forward with making arrangements for an adoption. And that's where the ICWA part comes into play, because if there's any reason to believe that that child could fall under ICWA applications, then we have a requirement to pursue all of the ICWA processes. So from an application perspective, that means that if a child is surrendered in one of the counties in Wyoming to a hospital, and maybe the hospital staff have no interaction with the mother, maybe the child is just literally found at the hospital, we would make arrangements for that child to be adopted. But at some point, ICWA would come into play, and there would have to be a notice provided to a tribe. And I think that the conversation we were having earlier was really about, this might be a nice opportunity to make some changes to safe haven, so that there's some guidance about when, where, and how to start initiating those ICWA steps and processes.
So fair enough. And are you kind of thinking on the safe haven law that we need to put into statute that ICWA applies, and then maybe some language, and maybe this is where we work between now and our next meeting to consider what language is in there to figure out what tribe how that notification goes out if there's no indication of tribal affiliation, right?
Mr. Chairman, I think it would be, I don't have the safe haven statute in front of me and haven't reviewed it for a while. So it would be worth considering what the language is in. It's in the existing safe haven state statute, and then evaluating how and when that might be impacted by the state ICWA statute.
Does that make sense up and down the road, that we maybe work on that to make sure that we're conforming with the intent of ICWA in our safe haven statute? Right?
Yes, sir.
Okay. Senator Case.
Definitely makes sense, Mr. Chairman, and in our research on this, maybe we could, other states have had to address this. I mean, other states have safe haven laws and have dealt with ICWA, so there's a lot to think about there. Really, if you have an unknown, I know if you go into Colorado, there's like signs on the fire halls that say this is a safe place, and it shows like a baby in a basket, looks like little Moses or something, and I mean, literally that's what happens sometimes. And so that's a really difficult thing to negotiate all that. So other states must have something. Maybe we could look into that.
Great point. And M, maybe if you wouldn't mind taking on that assignment and see what other states are doing, if they've got a provision in their safe haven to accommodate ICWA, that might save us from plowing that ground over again. But then we'll work. Ms. Robinson, please come up.
Mr. Chairman, thank you. What I would just share with
Have a seat.
the task force is that and maybe you are aware, or maybe you're not aware, is that both in Colorado And in Billings, Montana, there are ICWA courts that exist specifically for these cases. And that they may have law, they may have process that is in place. Specifically, I guess, in Billings because of the 7 tribes that are in Montana. And that where we are here, Lander and Riverton are border towns. So reservations that have border towns that have already been dealing with this, especially in the essence of safe haven.
Yeah.
And how the application of ICWA to.
Thank you.
Thank you, sir.
If you find something that you might think would benefit us, would you pass that on to us, please? Thanks. Okay, any other things that we'll want to consider as we consider? Mr. McAdams, please.
Hello again. In my, in the capacity as director of our ICWA program several years ago, I dealt with cases just like what you're talking about. And the safe haven law, like you said, did come in after the ICWA law. I worked with states, I won't mention the state, on cases where the parent gave up rights to the children at birth. And there was one case also where a child was turned over to like a police station, I think it was. We got informed of these cases and ICWA came into effect, and we relied on all of the aspects of ICWA to take custody of these children and to make sure that they were safely placed and taken care of. So I would appreciate it if you would, in your task force, would be to look favorably on the tribes taking custody of these children when issues like this comes up. So I wasn't aware, and I'm glad you got a task force here. Apparently, we got 3 tribal members here, or 4, who are members of this task force. Is that correct?
We have 2 representatives from each tribe.
Oh,
Representing the business councils from each tribe.
okay. That's good to know. Thank you.
And how that the request in the legislation, Mr. McAdams, was that each tribal business council make a recommendation to the governor, and then the governor appoints. So the governor could appoint whoever, but he would be able, but he wanted to consider the recommendations from the tribes. And so then, you know, kind of like we do for tribal liaisons.
Mhm. Okay, thank you.
Thank you. Ms. Johnson.
Chairman, one of the things, and I know it's hard with the safe haven law because we might not know who the parents are, but something to consider is that in the Mississippi Choctaw Indians v. Holyfield case, the domicile of the child and the jurisdiction over that case is where the parents were domiciled. So if we have a baby that's been given up by parents that live on the reservation, that is the tribe's jurisdiction to deal with that child and not the state.
But what if we're not on the reservation?
And that's where I get that we do have a problem if we don't know. And I agree with Ms. Robinson that we need to look at how other ICWA courts are handling this to trying to find a solution for that. But the Supreme Court has been very clear on the jurisdiction and the domicile.
No, and I think I think for the task force to remember, I think the easiest, it's so clear if it's on the reservation. That's the easiest. Tribal jurisdiction, right? It's in the rest of the state that we're trying to really hone down and refine and make sure that ICWA is complied with, because we do, if it's handled under tribal jurisdiction, then great. But it's when we get down into Albany County and Natrona County, Bighorn County, that and a child, and we may consider then how do we do this? And we're just trying to, that's what we're trying to clean up. Mrs. Neely.
Mr. Chairman, just to provide some context, the numbers of safe haven children that we have are minimal. Like I think we've had 4 or 5 in the last 9 years. So we're not talking about huge numbers, and we do always coordinate with our tribal partners because of course there is only a hospital. There is not a hospital for a mother to surrender or have a newborn in on the reservation. What the hope is that perhaps while we're evaluating the ICWA statute and potential, that maybe we could also use this opportunity to enhance some of our existing ones to support it.
Yep. Strike while the fire's hot. Yep. Okay. So with that in mind, we're going to that lays the ground for our next meeting, and then we're going to turn the time over now to Mr. Hopkins, our LSO staff attorney for this committee, and if you would take us through the Brackeen case and in both the majority opinion, the dissenting opinion, and we'll turn that time over to you, David. Thank you.
Thank you, Mr. Chairman. So I will just kind of give a brief overview of the case, and if anybody has any more specific questions, I'd be happy to go into details on anything that may need that. The case arose from originally 3 separate cases, child custody proceedings that were governed by ICWA, and then those were consolidated as well. They were brought by Texas, Louisiana, and Indiana, along with the individual plaintiffs in adoption proceedings or child custody proceedings. The primary challenges to the law were based on an argument that Congress, under its Article 1 authority, did not have authorization or is unable under the Constitution to create ICWA in the first place. Another argument was that the ICWA violated anti-commandeering provisions, in other words, by requiring the states to take certain actions. That was a violation in a sense of the state's sovereignty. They alleged that ICWA violated equal protection claims based on race due to the placement preferences. And then finally, there was a non-delegation challenge alleging that ICWA was delegating or unlawfully delegating congressional authority to tribes. The court held on that first claim, the majority opinion determined that the Constitution does grant Congress Article 1 authority, and it found that on a number of different grounds. It reviewed the history of the Constitution, found that and essentially summarized that Congress's power to legislate with respect to Indians was well established and broad, but not unbounded. It was plenary within its sphere. They found that under the Indian Commerce Clause, that commerce encompassed not only trade, but also other Indian affairs. And so they found authority under that, the Commerce Clause for ICWA to be established. They additionally discussed the treaty power as well as the foreign affairs powers, although primarily relying on the Indian Commerce Clause in finding that Congress could establish ICWA. The majority rejected the anti-commandeering challenge, finding that because those particular statutes that were challenged, or that particular statute applied to any party, and it wasn't just specific to the state with respect to active efforts to keep an Indian family together, that was not a violation, that the legislation applied even-handedly and thus did not implicate the 10th Amendment. the responded to a challenge that diligent search requirements in ICWA violated the anti-commandeering doctrine by noting that it doesn't actually command the state agencies to do anything, that diligent search is on the tribe to find someone else to step in for custody, as opposed to requiring the state to do that or perform that diligent search. They took a look specifically at the courts, the requirements that state courts have with respect to ICWA, and found that while indisputably it requires them to make placement preferences, that Congress does have the authority to require state courts, unlike executive agencies and legislatures, to enforce federal law. So under the power of Congress to require state courts to enforce federal law, that anti-commandeering doctrine did not apply. And finally, there was a challenge on because of essentially of the transfer of records, maintenance of records, et cetera, that violated the anti-commandeering doctrine. But the court held and found that Congress may impose those record keeping requirements related to state court proceedings without violating that 10th Amendment. And then with respect to the other claims, the court did not reach the merits on the claim of equal protection or the race-based classification challenges, nor on the non-delegation challenge, because none of the parties before the court had standing. So on those issues, the court didn't make any holding with respect to those. And so the end result is that ICWA has been upheld in this case. The dissent, two dissenting justices, Justice Thomas and Justice Alito. Justice Thomas's dissent essentially takes issue with the finding of that the Indian Commerce Clause allows for ICWA by noting that commerce, or he would restrict it simply to trade and issues of commerce, and notes that commerce is not about children. And he would note that the plenary power that the majority discussed does not extend beyond what their enumerated authority is, and he would limit that authority again on that that respect to commerce, and find that Congress does not have the Article I authority to establish ICWA. And Justice Alito was along the same lines. Taking issue with he emphasized a little bit more heavily, at least, that the powers retained by states, and he focused on the powers, or the retention of powers by the states in the Constitution, noting that he notes that while we have never comprehensively enumerated the state's reserved power, we have long recognized the governance and family relations, including marriage relationships and child custody, is among them. And so he would have, again, found that Congress did not have the Article I authority based on an argument that was a power to regulate that was left to the states and not to the federal government in those domestic relations situations. And with that, Mr. Chairman, I'd be happy to answer any specific questions that anybody may have on this.
Committee members, any questions or comments as on the explanation or from your reads on the opinions of the Brackeen case? I thought it was a fascinating read. I think for me, the important context of was Justice Gorsuch's pointing out that the pendulum in ICWA, once it was established, had started to swing away from the original intent, and that we've seen that erosion take place, and that this is a critical effort in helping to bring back the original intent of ICWA and how it's applied in in law across the country. I also think that I thought it was really important that he talked about how the Indian Child Welfare Act was not created in a vacuum. It wasn't done in Congress in the dark of night, that it was really in response to generations of removing children from tribal families and putting them in inappropriate settings where we done more harm than good. I thought the other really compelling argument in the important thing that Gorsuch taught is, and it's really important for us here in Wyoming to understand, is this idea of sovereignty, that a tribe, whether it be many or one, is a sovereign. And that when this individual, although they belong to a greater body, as an individual in the United States is still a sovereign, and that is granted to them not by the fact of their race, but by a treaty with United States government. And I think that we lose sight of that. And so when the Indian Child Welfare Act was created, it was brought back in trying to preserve that sovereignty and the ability for those sovereigns to have a say on the future and the stability of their own within the existence of the United States of America. And so I think that as we consider this, and maybe I'm not getting that right, but that's my take and my opinion on it, that the preservation of the act was really important. I think the dissenting opinion, although their arguments were interesting, I think the plenary argument that Justice Thomas points out, even from my uneducated mind, I thought that was interesting because I didn't think it held much water. And so I would just hoping, if I can find it here, this is in the last paragraph of Director Gorsuch. Chairman Ellis actually brought me on to this first, and I'd just like to read that. It says, often Native American tribes have come to this court seeking justice only to leave with bowed heads and empty hands. But that is not because this court has no justice to offer them. Our Constitution reserves for the tribes a place, an enduring place in the structure of American life. It promises them sovereignty for as long as they wish to keep it. And it secures that promise by divesting states of authority over Indian affairs and by giving federal government certain significant but limited enumerated powers aimed at building a lasting peace. In adopting the Indian Child Welfare Act, Congress exercised that lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. All that is in keeping with the Constitution's original design. So when we consider what we're doing in enhancing ICWA, my suggestion to this task force is that we remember that they are said that there are tribal members here in Wyoming are members of the state, but they're granted sovereignty as well. And with that sovereignty comes rights that are enumerated through the treaty relationships. So any other thoughts or comments? Okay. With that, it is my recommendation that we'll get another, do we have another meeting scheduled this time, David? So I'm going to ask Emily if she'll reach out to us and look at calendars. But I think that, if we could look at maybe late August, early September, late August, September, and hopefully that gives us some time to work with our agencies and task force members to consider the tasks that we're we're wanting to look at enhancing and come back with some something to work on at our next meeting. Okay? Any other comments? Any other public comment? Vocal bunch, isn't it? Thank you. With that, we'll
Mr. Co-Chairman?
this meeting's adjourned. Oh, there you look who's here. Yes.
Oh, I just
Chairman
wanted to
Ellis.
apologize. I just apologize to everyone. Getting stranded at camps and whatnot. So I just want to apologize for not being there. Was able to do most of the discussion today, but we'll follow up and rewatch the recording. Thank you for coming and being prepared and having ideas. I do think we have important work to consider. And we'll just look forward to the next meeting. And again, I just want to apologize to everyone for missing today.
Well, you sound like you're around Muddy Gap right now. So. Very good. Thank you for making the effort. And with that, we'll call it a day. Thank you. Good job, David.